deals with matters of financial conduct authority and Avacade Ltd and others.
My Lords, I hope you have received from my learned junior, Mr. Temple, via Miss Davidson, a soft copy of some further authorities which are definitely tabbed and which Mr. Temple says are tabbed with the same pagination as the hard copy. And for my Lord Justice Popplewell, there is a hard copy in a white file of the same material. There isn't a hard copy for the balance of the court unless you want it, but we proffered it and were told that you were unlikely to want it.
You didn't want them, did you?
No, so much so that they've taken away my little side table today, which is fine.
Is that fine?
First point, can I revert to the question I was asked yesterday about an idea of the size of the pension pots transferred and just give you the figures on that. For Avacade, there were in total 1,943 clients. The smallest pension transferred...
Sorry, what was that figure again?
1,943 clients. And I'm going to give the following figures to the nearest 1,000. The smallest pension transferred was 8,000. The largest transfer was 393,000. And the average, in the sense of the mean, not the median, the average mean was 45,000. For AA, Alexandra Associates, there were only 59 clients. The minimum pension size transferred was 11,000. The maximum was 490,000. And the average, again in the sense of the mean, was 88,000. So that just gives an idea. And so, in a sense, we were right, I think, to say that the typical pot was a relatively modest pension pot. The next outstanding question I have to grapple is what is a SIP? That's a little bit more difficult. But if you could go to volume 2 at page 6 in the hard copy.
Sorry, volume 2 of...
it's called Appellant's Agreed Supplementary Bundle for the Appeal Hearing, volume 2.
And that's not authorities.
Not authorities.
I've got agreed supplementary bundle which starts with sealed orders.
Yes, that's the one.
Okay, thank you.
And we want in the hard copy, page 6, which should be the Liberty SIP, terms and conditions.
Yeah.
And this is, it seems to be without doubt, a contractual document between the pension holder and Liberty SIP Limited, but it refers to a trust arrangement in which the trustee is a different entity, Liberty Trustees Limited. We do not have the trust deed, but we get a pretty clear idea of what it does from these terms and conditions. When we had the Adams case, we did have the trust deed to look at, needless to say. So this, as you can see at clause 2.1, records that the Liberty Pension Scheme is a registered pension scheme which has been established for the provision of pension and lump sum benefits. Arrangements to receive a transfer of protected rights under the terms of Schedule 1 of the Trust Deed and rules in the form of a sub-trust of which a member... the scheme is intended to be an appropriate pension scheme within the meaning of the Pension Schemes Act. And it relates to a series of arrangements and at 2.2 it says that your individual SIP arrangement and group SIP arrangement is made up of 1,000 separate segments which will be held as provided for in the trust deed and rules within one or more arrangements between you and us for the purposes of the Act.
And who is us?
So us is Liberty SIP Limited.
And is that the trustee?
No, that's not the trustee. The trust. So
And
if you,
I note that the trust, it says that the sub-trust of which a member and the trustees are trustees.
exactly. So it says at 2.3, the scheme is governed by a trust deed and rules called the trust deed and rules respectively, as amended by any subsequent deeds. So, and it says we are the scheme establisher and operator, so that's Liberty SIP Limited, and Liberty Trustees Limited is the trustee of the scheme. There are a series of provisions about contributions at clause 4, but I don't think that matters particularly. If we go over the page to bundle, hard copy bundle, page 7, clause 5, the bottom right-hand corner, exercise of investment options, Liberty SIP Limited, so that's the operator, is not authorised to give investment or financial advice. You must direct the manner in which the funds within your arrangements are to be invested. Neither the trustees nor we accept any liability for any decisions relating to the purchase, retention, sale, ... And if we go over the page to 5.2, subject to paragraph 5.3 below, the trustees will normally give effect to your investment decisions, directions, and as soon as reasonably practicable after the same is made, ... However, the trustees are not obliged to give effect to your due exercise of an investment decision or direction. So all of us with SIPs might have thought that we were entitled to direct. It's not quite as simple as that. And at 5.3, the trustee shall cease to give effect to, or as the case may be, to continue to give effect to your due exercise of an investment decision if it's shown that you're incapable. That's 5.3.1. 5.3.2, which is not outdented properly, you're dead. 5.3.3, that it will be unlawful to do so. And 5.3.4, there's some event or circumstance brought to the attention of the trustees which make it inappropriate. So I suppose in one sense there's a residual discretion. And then at clause 11, termination, each arrangement within the scheme will terminate immediately upon expiry of notice, or perhaps most pertinently at 11.3, the provision of annuity or death benefits in the appropriate form. So you can sort of turn into, you can take tranches of it and turn it into your pension entitlement. So as we understand the position, there is a contractual arrangement with the provider, but underlying it there is a trust arrangement, and it is within the trust that the investments, which might themselves be regulated, what might be securities or might not, it's within them that it's within the trust that those investments are held. So that I think the point in Adams is that what you have qua beneficiary of that trust is rights to benefits from the scheme property, rather than any right over the scheme property itself.
That might not be the same where the member is a trustee.
It might not.
Well, was the member a trustee in Adams?
I'm afraid I don't know. I can't remember.
I mean, it seems to me that it's absolutely bristling with issues.
Yes.
Maybe none of which is important to us, but it is just nice to know
Yes.
that could potentially be bristling with issues.
Yes.
particularly in the light of the approach taken in Adams.
Yes.
Yes. Anyway, I'm very grateful to you for taking the time to show us that, Mr. Bynum.
And you've described this as a contractual arrangement, but there were certainly there were conditions in Adams as well, weren't there, which gave the right to direct investments. And
Yes.
those were not to be relevant rights under a contract.
Quite.
Right.
Could you just walk us through the progress of the money from either an occupational pension or from a personal pension to the point when it is invested?
Yes.
What is its journey?
Well, as I understand it, the old scheme trustees will realise the assets and produce cash. Cash will be sent to the new SIP trustees. There will be cash within the SIP trust, and that cash will be used to buy whatever investments the new scheme invests in.
And what is the mechanism by which instructions are given by the investor to the trustees?
There is a letter of instruction, and that was, I think it's, Mr. Temple's going to help me with this, that was drafted for them, I think by Avacade in this case, but the investor then sends that instruction.
Right, so it's part of the package of paperwork that the investor who's changing their pension is given, and in practical terms, I mean, I don't know whether it matters, but once that instruction has been given, which is all taking place as part of the handover, the obligation, for example, in the Liberty case, is as soon as possible to execute the instruction.
Yes.
And so in real terms, the money is, insofar as it's possible, going straight from the original pension pot into whatever the investment is, whether it be trees or pods or
Yes.
whatever, as soon as that can possibly be
Exactly.
achieved.
It lands and pauses as cash in the SIP. I think there's no doubt about that. There's not a bypassing,
Understand that?
but on a temporal basis, it's as soon as may be.
Yes, so it isn't that it goes into the SIP. Everybody sits around and thinks, well, what are we going to do now? It arrives badged for investment in
Let me
whatever has been
just
instructed.
Mr. Temple reminds me that in the investment call, you recall the pattern was two telephone calls essentially with the clients. The first is a general one about wouldn't it be a good idea to free up your pension so you can invest it in various things which give higher yield than what you've got at the moment. And when the investor has agreed to that, there is then the second call, the so-called investment call, in which the way in which it is put is your transfer is underway. What shall we in fact decide to put the money into?
The first call was called what?
The report call.
The report call and then the investment call.
Yes. It is all set out in the judgment.
It's set out, there's a very clear statement in the judgment, which your lordships can take from page 158 of the judgment of Adam Johnson, from paragraph 92, and he describes each step.
Thank you very much.
Including the investment call, which is step 9. It's a very helpful sequence.
Thank you.
And if I'll give your lordships a reference, if you wanted to see an instruction from an investor to Liberty SIP in the unagreed bundle, volume 3, page 74, there is an example of that. my lords. Unless I can assist any further with that, the next point I wanted to deal with was, I think, the Master of the Rolls question to me yesterday, which, if I understood it correctly, and I'm probably clumsily paraphrasing, but I think was, if the FCA's, if the approach which the FCA urges in this case, in terms of unbraided stream or unitary approach, were right, is there a danger that that might cause problems in other regulatory contexts? So let me give my answer to that. In short, the answer is no, because all cases turn on their facts. Whereas here, a regulated activity is carried out by an unauthorized person, it is that activity, that breach of the perimeter, which gives rise to regulatory consequences. There is no enlargement of what constitutes a regulated activity by the approach which we urge on the court. No one who was not a contravener before will be turned into a contravener by taking the approach that we have adopted. The question really comes down to asking what an activity is or what arrangements are, to see if it or part of it, part of that activity or part of those arrangements, is caught inside the perimeter. So that's the first point. Second point is a policy point. The drawing of the perimeter is intended to achieve a situation where the unscrupulous or incompetent or self-interested who might have adverse effects on consumers in the financial services sphere are kept away from them. That is what it is for. And there is certainly no policy reason to be shy in one's approach to where the perimeter is drawn from that point of view. And just pausing there, there's the Adams case highlights a really elegant bit of self-policing in the statutory structure, because remember that in Adams, the reason why the SIP providers were caught is because they accepted a client from someone who was unauthorized, who needed to be regulated to do that, and the SIP provider, even though they may not themselves have done anything wrong, have crossed the perimeter, is nevertheless subject to the transaction being unravelled because of how the person got to them. And it's a very neat bit of statutory machinery, that. So perhaps I've not made that quite clear. But so the SIP provider in Adams, there were arguments that the SIP provider had breached the SIP provider's actual duties, but they weren't resolved. Nevertheless, the client in Adams is unable to unravel the SIP and therefore get his money back from the SIP provider, not because the SIP provider has strayed across the perimeter line, but because the SIP provider was introduced by someone who had crossed the perimeter. And so that's it's a neat, we would say, kind of self-policing, in that it means that authorized people have to be very careful about how it is they come to be dealing with consumers. So as an authorized person, you may find yourself in trouble because you breached the rules. As an unauthorized person, you will find yourself in trouble if you do something you're not supposed to do. But even as an authorized person carrying on a regulated activity, you can find yourself in trouble when you get business from from someone who ought to have been authorised.
Can I ask you two questions, Mr. Vinyl, only partly related to what you've just said? I've just been looking at Adams and the reasoning of the Court of Appeal in paragraph 63, well, 60 to 65. It seems perfectly plain, actually, that if, in this case, the member was a trustee, and I'm assuming for this purpose that liberty terms are the same terms as every other member had, that may or may not be correct. The reasoning there simply does not apply in this case, because if you look at 63, this passage recognised, Mr. Moran submitted, that a member of a personal pension scheme may have a right to receive sums determined by reference to the value or performance of the underlying property, but does not have any entitlement to the property itself. And then he says, in my view, Mr. Moran is right about this, and he says, a member of the Carey pension scheme, such as Mr. Adams, enjoys his rights pursuant to the trusts established, which provide for the scheme to be governed by the rules. It's true that he says you may direct us to invest. However, the terms and conditions explain that it's governed by the rules. If the terms and conditions can be said to have given a member a contractual right, and then he says, in 65, in any case, I do not think a member of the Carey pension scheme converts, disposes, or sells of his rights merely by altering the underlying instruments. And the reason for that is because, of course, he doesn't there, but he does here, because the underlying instruments are held by the trustees of which he's one. So, in fact, I think, I'm putting to you, please rebut if I'm wrong, here Carey is of no relevance at all. The reasoning in Carey is of no relevance.
Insofar as liberty was the SIP provider.
Yeah,
Insofar as liberty. I see the force of that. I'm grateful.
Well, that may cut through quite a bit of this
Maybe.
case, in fact.
Yeah.
But I mean, we'll have to check it up, and so as to avoid the need for you both to scurry around today, I suggest we conclude the argument, and you have both liberty to put in written submissions in a fairly short time scale as to whether points that emerge from the bench are good, bad, or indifferent, and you will no doubt take some much more expert advice on that before you do.
Yes.
But it is significant because the whole case for the additional grounds is put on the basis of Carey and the relevance of Carey and so on. So if there is a sort of flaw, it would be good to expose it.
I understand that.
Sorry, Mr. Vinyl, I interrupted.
It's very helpful, my lord. So what I was dealing with was this question of as to whether there's a hidden danger in the unitary approach, and I've suggested that, in a sense, in terms of liability, whether someone has crossed the perimeter, there's no danger at all arising, because no, it's not a consequence of not slicing things up that things get caught which wouldn't otherwise be caught. That's not what we're doing. We would suggest that insofar as there is any policy issue or policy risk of overreach or overstretch arising out of the question of where you draw the envelope around a set of arrangements, it seems to us actually it's a question which goes to remedy rather than questions of breach. If it's a question at all, it's a question which goes to remedy. Of course, that then engages the new point which my learned friend wants to run on section 382. And there, of course, the question is whether a particular loss or benefit was caused by the contravention.
You accept that's a new point?
Yes. It's plainly a new point.
So,
may or may not be open to him, but but on
well,
the policy
if it is a new point, you would accept, I think, that the application for permission to amend the notice of appeal so as to run it is an application which can succeed with the permission of the court under CPR Part 52, I think it's 10, and not an application to reopen under Part 52.
Right, I'm going to come on to that, but that's exact spot on, actually, yes.
Okay, good.
So I'm going to address it, but anyway, it's a question which arises on the policy point.
Yes,
even if it's not a formal.
I mean, obviously, you say they shouldn't have permission because it's going to fail, and you're going to tell us why.
Yeah.
But I need to know what test we're applying.
Exactly. But we would say, really, when you get to those Section 382 questions, the court is engaged on the type of inquiry which it so frequently has to make in relation to loss. Is the loss, how is the loss connected to the contravention? Might it be said it's a case where the contravention merely provides the occasion for the loss to be sustained, the Galoo and Bright Murray question?
I haven't heard that case mentioned.
No, but it's a very elegant way of putting the question, I've always thought. Does it merely provide the occasion for the loss to be sustained, or is it in some sense a cause of it? So the question is the contravention properly the, or at least a, cause of the loss? And then, under Section 382, there's the additional fact that it's a discretionary remedy. And in answering those questions, which the courts have to answer all over the place, maybe one actually looks at causative potency, back to the point which was attractive to the Court of Appeal in Adams, about when does one thing cause another, the question which has foxed philosophers since the days of the Greeks. I mean, there's no shortcuts on causation, there's no litmus test.
Isn't it better, rather than putting up substitutes, to just read the words of the section?
Right.
I mean, it's as a result of.
Exactly. And precisely, and we would say, where a particular consequence is exactly what you intended and hoped for, indeed the very purpose of some things which you did, which were inextricably linked the one with the other, very difficult to say it's not the result. But that will be a matter for the courts to decide on the facts of each case. And the judge, in fact, touched on this at his paragraph 249, if I can take you to that. In the context of Article 29, where there was a similar salami slicing or meat cleaver point, we referred the court to 3 decisions in the financial services context, which are in fact decisions which go to what is the consequence of a breach and what is the appropriate financial remedy for the breach. And they're the 3 cases set out there at Walker and Inter Allianz Emptage in the FSCS and a FOS case. And the judge gives the relevant references. We've put those cases in the bundle. They are, as it happens, all cases where the answer to the question, does the loss flow from the breach, was yes, against arguments that it didn't flow from the breach, that you could find something which perhaps broke the chain of causation or meant that it wasn't the result. So the point has been answered in our case. It has been answered appropriately in our case, we would say. And the fact that there may be cases where the answer is no, that there's a regulatory perimeter breach and something then happens which is so distinct or is sufficiently distinct that you wouldn't say the loss is a result of the first thing, that doesn't pose a systematic or in principle problem. It's just that kind of problem that courts have to deal with all the time. So that's my submission on Your Lordship's question. Does this raise a wider problem?
It's very helpful.
They're slightly different, aren't they? 382(1)(a) and B, in that the first is the profits accruing to the contravenor.
Yes.
And if there's a contravention and there are profits, then it might be quite easy to see that the one result from the other. Losses, on the other hand, maybe it might be a more complicated inquiry to establish why the losses occurred.
Quite.
But there may be, I mean, I'm just throwing out that 1A may provide a shorter road in some cases where there's obviously a contravention and obviously profit.
Yes. Although in a sense, to be fair to learned friend, it is undoubtedly true that it is at the later stage.
Yes, I understand that point,
yes.
but there are two ways in, A or B.
Quite.
And they may not be exactly symmetrical.
Oh, quite. And they certainly lead to different results. If this were a case in which the defendants, that is to say the personal defendants, because the corporates have no money, in which the individual defendants had oodles of money, we might be spending time and effort to establish the losses of the investors. But because it is not a case where the defendants are good for a massive award against them, we have not done that. We have sought our interim restitution order essentially on the basis of the profits accruing much.
But one could imagine theoretically a case in which people were acting in an area where they had no business to be acting, made profits from it, but by some miracle Costa Rican teak turned out to be a very good investment. It still wouldn't remove the teeth from 382.
No, you could still disgorge the profits if it was thought appropriate to do so.
Yes. Thank you.
And I think one, perhaps the only final point on that is there are two remedies. I think one has to be careful about not overcompensating. I think it would be quite difficult to say it was an appropriate exercise of the court's discretion both to disgorge and impose a liability for losses without giving credit for the disgorgement against the liability for losses. But there would be a happy case where that even arose as a practical point. So can I go back, but I think quite briefly, to the substance of the appeal as it originally came before the court. And this is where I broke off yesterday. And it may be helpful to have the grounds open. I dealt with ground 1, which was an alleged inconsistency in the use of making arrangements. Ground 2 is the judge erred in failing to have regard to the need for the claimant to demonstrate a real causal link between the activities alleged to be making arrangements and the relevant transaction. And ground 3 seems to us to be parasitic upon that, because says accordingly the judge erred by not applying the correct causation test. Now it looked from the skeleton argument as though this was going to be put on some basis that the causation test in RAO 26, which only applies to 25.1, is somehow snuck into 25.2. That argument hasn't really been advanced and is with great respect, plainly hopeless. It seems to us that the judge dealt perfectly properly with such causation question as there is at his paragraph 2272. And 3. So he talks about bringing about in relation to RAO 25.1, and he says, by contrast, Article 25.2, this is 227 sub 3, Article 25.2 is broader, seems apt to capture arrangements which, although they do not or would not necessarily bring about the transaction in the direct sense of causing it to occur, are nonetheless performed with a view to encouraging or assisting it to happen. He says, the phrase with a view to describes a more inchoate form of activity which is not necessarily causative of the transaction in the sense that it brings it about. And with the greatest respect, we entirely adopt and repeat that. There is a difference. 25.2 is wider.
He says, nonetheless helps it to happen. Is that needed?
Well, it's not needed as part of the test. It's arrangements with a view to.
So it goes a bit too far. Nonetheless helps it to happen, because if the requirement is that it's sorry, I haven't got the wording in my mind. With a view to the consumer, whatever it is, buying investments or whatever the words are.
Yes. I suppose in a sense he has got to. If what he means it, but nevertheless it is a requirement that it helps it to happen, in fact, he has gone too far. If he's saying it doesn't matter whether, as it turns out, it helped it to happen, he's right.
Well, sorry, the words are making arrangements with a view to the consumer subscribing for investments.
Yes.
So, I mean, I suppose it would be surprising if the making of the arrangements did not help it happen, because in one sense, I mean, it may be a bad point.
I mean, just looking at the statutory language, does with a view to mean anything more than that the intended consequence?
Quite.
It is that consequence in the sense of it is intended that it will help it to happen.
Exactly, and the judge, in a slightly different context, but of the same words, if you look at his paragraph 252, and here he's dealing in RAO 33 with the question of an introduction with a view to the provision of independent advice.
I'm so sorry, which paragraph?
Okay. 252.
Thank you.
So here he's dealing with the same words, but in RAO 33, where the question is an introduction with a view to, and he says at 252, the words with a view to, as I've already noted, to my mind demand an assessment of the purpose of the activities. What were they for, or to put it another way, what end result were they intended to achieve? And I think that's exactly my Lord Justice Popplewell's point. And he then applies that at 254. And he says, you know, even the early stage of collecting data from existing pension providers, he says, looked at in context, bearing in mind Avacade's own commercial interests as a business, the point on which I started yesterday, it seems to me fair to say it was with a view to bringing about a situation in which existing pension funds are liberated and then invested in products from which Avacade might make a commission. So that's all that I wanted to say on grounds 2 and 3 of the original appeal. Ground 9 of the original appeal is a narrow point, not an unimportant point, but a narrow point on the syntax of RAO 33, and the learned friend did not succeed in obtaining permission for any of his grounds that follow on the application of RAO 33. On the question of construction, which is just a syntactical question, perhaps we better have open RAO 33. Which is in the main authorities bundle, hard copy page 45, which I think might be 47 in the soft copy. Uh, 44. So it's 33 little c. The draftsman's been a bit short of commas or semicolons. The introduction is made with a view to the provision of independent advice, or the independent exercise of discretion in relation to investments generally, or in relation to any class of investments to which the arrangements relate. And the question is really how you scan that. And we say that there's really an either or followed by another either or. And in support of that, just on a sort of grammatical and drafting point, we would say if you're really dividing this into, on the one hand, an introduction made with a view to the provision of independent advice, or on the other hand, everything that follows, you really would want to put in a comma or some form of indication that that was the case. Because this is actually quite balanced on our reading. You have two things which are broadly similar, that is to say, the provision of independent advice or the independent exercise of discretion. In other words, are you going to an advisor or are you giving someone discretionary management powers? And in either case, it must be either in relation to investments generally or in relation to a class. So, and that seems a much more natural reading of that provision. So it seems to us. That is, of course, what the judge found.
And it fits with the policy, which is to create a firebreak, as it were, exactly, in relation to introductions. If either there's going to be a discretion or there's going to be independent advice, because that's then going to be that which has causative potency.
Exactly. And that was my second point. So the first point is just grammatically our reading looks better, and secondly, from a policy perspective, it plainly looks better. But the learned friend, in a sense, didn't really press that very far, and he was right not to do so because it doesn't make any difference to the outcome anyway.
You would say, I suppose, that if the alternative reading was correct, then it would have made much more sense to have made the second half of C into D and renumber.
Yeah, yes, not to insert it into the existing.
The introduction is made
but
C with
yes,
a view to, and then D, the introduction is made with a view to.
Yes, with an or between them, but exactly. Much more natural. Or even a semicolon or something would probably be enough to disambiguate it, but there's nothing there. Then, subject to whether you permit it, there is the RAO 29 challenge. So not in the original grounds, and all the grounds on RAO 29 were refused, but it seems to us that this is a bad point because there is one set of arrangements, precisely as the judge said. I'm not going to take you to them again, but the references at para 231 sub 2, 248 and 286. But if we look at RAO 29, page 40 in the bundle, and as my Lord Justice Popplewell has already pointed out, the question here is not only pecuniary award. There is excluded from both limbs of Article RAO 25 arrangements made by a non-authorised person with a view to a transaction which is or is to be entered into by a person with or through an authorised person, so that would be the SIP provider, if the transaction is or is to be entered into on advice to the client by an authorised person. Well, the whole point of the liberty arrangements and the SIP arrangements were that they were execution only. And it's not enough for my learned friend to say, well, they may have some residual discretion as to whether they accept business or not. So it doesn't satisfy A. The next...
Sorry, the transaction we're concentrating on for A is entry into the SIP.
Yes, here.
Not the
the
execution of the investments pursuant to the execution-only instruction.
Yes. Yes.
And the entry into the SIP, as the judge found, was something that Avacade and AA advised the clients to do.
Exactly, and that's why B, you can't take the B limb. So it's not entered to on advice by the authorised person because the SIP provider wasn't advising on the merits of entering into the SIP. So to cross out A, also, and it's the option, cross out B because there was advice from the non-authorised person. Well, that obviously can't save it.
No, and there might have been advice from the IFA, but that's not the case in most cases.
No, and in any event, as the judge found, that was very constrained, a very constrained advice. And so we would say you don't get off the starting blocks on RAO 29, but if you do get off the starting blocks, it doesn't apply anyway because of sub 2. Not 2A, that's irrelevant, but A, so that's conveniently Avacade, receives from any person other than the client a pecuniary reward or advantage for which he does not account to the client, and of course they didn't, arising out of his making the arrangements. Now, if we're correct on the holistic approach, well, obviously they did. Even if we're not correct on the holistic approach, there's then a bit of a mixed economy. Avacade did receive sums of £750 from Barclay Burt, but I can't press that too hard because there was only limited numbers where we knew that had happened. So
I thought they all received £80. I thought there was £80 every time it went into a SIP.
No, there was. No, I don't think that's right. Yeah, with AA.
AA. £95 from
Yes,
Blackstar.
I've written £95. Yeah,
Blackstar for all the AA ones.
exactly.
And some of the discretionary management fees too, from what they were called.
From both securities.
Thank you.
Yeah.
But the Avacade ones,
But it's not a knockout point for me on Avacade.
not.
But that's what we say about RA.
And I've been looking at the, as we've been talking, the incidence of liberty as against Barclay, whatever it was, the Barclay SIP. It looks as if, from the judgment, as if the Barclay SIP was very rare, just a few cases at the beginning, so that the terms we have got of the liberty SIP are in fact mostly, if not
predominantly
99% applicable. Looks like.
But then there was a Guinness Marne SIP for the
bits and pieces at a later stage.
at a later stage.
We don't know about that. We haven't got those terms in the bundle.
Can I then, unless I can assist any further on those sort of substantive points, turn to the procedural point?
Sorry, just on the last of those points, where you say it's not a knockout blow for Avacade, that's because you accept that you've got to look at the arrangements individually, customer by customer. Because if you could look at them holistically, then the fact you're obtaining a pecuniary advantage in relation to some aspects of the implementation of the scheme
Yes,
might be said to disapply 29 altogether.
Well, I hadn't thought of that.
Well, I don't want
I
to
think
encourage
it- I
you to
think it
take a
might
point
be-
you don't
no,
think
I
it's
think it
appropriate
might
to
be-
take. That's not a point you're
The
taking.
problem, I think, is with the word a transaction for that purpose.
Yes. It's not a point I'm taking.
No, thank you.
So, the procedural point, not all perhaps altogether easy, this procedural point. So to begin with just two facts, which ones are a bit easier. The point about the impact of Adams, or at least the point about whether there's a purchase or sale of securities, was canvassed below, but not pursued by my learned friend. And in our supplementary skeleton, which dealt with the application for permission, we just set out at page 8 the passage before the judge below. If I could just take you to that. Learned friend at day 10, page 16 of the transcript said, I can't really adopt any argument. Mr. Lee Lummis may have been wanting to advance that, for example, if the money is then used to buy, say, a commercial property or to buy trees, that isn't in itself effectively sufficiently disposing and therefore buying or selling of the SIP within the personal pension scheme.
So where are you reading?
I'm reading page 8 of our supplementary skeleton, dated 1st of July. Paragraph 19, 2b on page 8.
The FCA's written closing.
Yes.
Right.
And then I'm taking you to the exchanges in the court below, which are set out there.
Yep.
So it was obviously an element in the way we put our case, but it was not challenged in the court below. And the second sort of factual point before we get started is, as you know, there were 28 grounds of appeal for which permission was sought, of which only 4 was permission granted by Lady Justice Aspin, and what I'll call the Adams point was not one of them. So that's our sort of starting point. This is not a point that was in contention below, nor was it a point for which permission was sought. Now, what my learned friend wants to do with his new points does not seem to us to be fairly characterized as reopening of an appeal, because he is not making an attempt to say that this ground of appeal was wrongly refused permission. And since the substantive appeal is not yet over, there can't be a question of reopening the substantive appeal. So this, it seems to us, is not a reopening case under CPR 5230.
Why is it not a reopening case insofar as the ground has been refused permission by Lady Justice Aspin?
Because he didn't ask for it.
Oh, I see. I'm sorry. On the Adams.
On the Adams point.
Sorry.
Yeah.
On other points, it would be.
Maybe a little bit different.
Well,
But there's a different answer to the new appeal on those points. points, which is finality. I'll come to that later.
But which of the other points do you say it applies to? Article 29? Because
The Article 29 point, as it's sought to be put, I think is to some extent parasitic on the Adams point.
yes, and the grounds on which permission was sought and was refused on Article 29 are not those.
Quite. So
on
ground
which the new
2
grounds
is it?
are being advanced.
Exactly.
So your submission is that in fact none of the grounds Mr. Markley is seeking to argue that go beyond the original grounds constitute reopening.
Yes. Not a reopening case.
Thank you.
That's not in itself fatal, but it's not a reopening case.
No.
Now, if it is reopening, which we say it isn't, which we know, we've seen what 5230 says, we identify as the most recent case, the decision which is in the supplementary bundle at tab 8.
You're saying if it is a reopening?
Yes, I'm just trying to help the court on reopenings. I say it's not a reopening.
It's not a reopening.
It's not a reopening, but if you want to know
What
the
the law
up-to-date
is.
thinking on reopenings,
Yeah.
Lady Justice Simler, in a case called Tomanovich, which is tab 8 of the new authorities.
You really don't need to go to a single lady justice. I mean, the authorities are really, really well known on reopening.
Well, and it was only that there is a review here which includes Wingfield and Canterbury City Council, which was a full Court of Appeal in 2020,
Yep.
summarised at paragraph 15 of this.
I mean, it's really Goring, Winfield, Circle, and Taylor and Lyon.
Exactly. So they're all there, and
I mean, they're very, very well
Exactly.
known now. Yeah.
Good. So, if it's not a reopening, what could it be? It could be an out-of-time application for permission, a fresh but out-of-time application for permission, or it could be an application to amend the grounds of appeal. If and insofar as it is characterised as an out-of-time application for permission, it is surely hopeless because it is so manifestly out of time, and it would not normally be a good ground for a way out of time fresh application that the Court of Appeal has said something in the interim which made people change their mind. So it can't succeed as an out of time application for permission. The more difficult point is, can and should it succeed as an application to amend the grounds of appeal? Now, as to that, can we go to the White Book and 5217 and its notes? Couched in beautifully negative terms, an appeal notice may not be amended without the permission of the appeal court. And the notes are not terribly full.
They're not fulsome, are they?
They're not generous to the poor practitioner, and they also contain a typo. It says, where a proposed amendment raises a power argued in the lower court. That must mean raises a point argued in the lower court. If it is sought timelessly, it may not prejudice the parties or litigants in other appeals. It may be permitted, subject to the general principles governing amendments, see the commentary to Part 17. Where a proposed amendment raises a point not argued in the lower court, see 5221.1.1, and that takes us to the authorities set out there about the stance which the Court of Appeal should take towards a point not raised at trial in the High Court. and raised for the first time on appeal. Said to be a discretion that, quote, ought to be most jealously scrutinised. And then there's some criteria set out by Lord Justice Hatton Cave in the case of Singh. An appellate court will be cautious about allowing a new point to be raised on appeal that wasn't raised below. An appellate court will not generally permit a new point to be raised on appeal if that point is such that it would necessitate new evidence, or the trial would have been
So
different.
where are you reading now?
So notes to 52.21.1.1.
Page 1879.
Yes.
Sorry, thank you.
1879.
1879. Some guidance from Lord Justice Hatton Cave in a case called Singh set out. And then it said there is no general rule that a case needs to be exceptional for an appellate court to permit a new point to be raised on appeal. And that cites a case called Notting Hill Finance. I wanted to take you briefly to three of the cases in a moment, but I think probably it could be said by my learned friend that the hurdles here do not seem to be so high as the exceptionality hurdles of reopening something that is closed. And perhaps there is a distinction, an analytical distinction which one needs to grapple with here. Is an appellate court seized of the list between the parties, with the parties constrained pro tem by whatever happens to be set out in the grounds of appeal? That would be one analysis. So that this court sitting here is in a sense seized of the case, although procedurally constrained by the grounds of appeal. Or is the analysis that this court as it sits today is seized only of the issues raised in the grounds of appeal? Now, if it's the latter, one can see a jurisdictional problem with a new point of appeal being raised. But if it's the former, that you are seized of the list between the parties because we are here and you want to do justice in the case, one can see that perhaps the issue comes down to the rights and wrongs of permitting the amendment. If it's that analysis, then that's obviously better for the learned friend. And the FCA, as regulator, understands that there might be some disquiet if an appellate court seized of an appeal were somehow constrained to proceed without taking into account an intervening decision of the Court of Appeal, which appeared to be on point. As a point of principle, and it's really a point against myself, but we can see that the more attractive analysis might be that this court is seized of the list in general, subject to a procedural but not a jurisdictional constraint arising out of the grounds of appeal. Now, if you were to approach the matter in that way and treat this as an application to amend, and if there is a concern about opening the floodgates, there is in fact a very straightforward way of making sure that the floodgates are not open, because the present scenario is surely quite unusual, where the new point that is sought to be run, it is one which, I mean, frankly, both parties reasonably believe the law to be, as the FCA
Is
told
5221 relevant? That tells us that every appeal is limited to a review of the decision of the lower court. If it wanted to say every appeal is limited to the points that the parties bring, it could have said that.
Yes.
It clearly is also designed to say it's not going to be a rehearing unless the court considers it should be a rehearing.
Yes.
But we're engaged, as I understand it, in a review.
Yes. And, you know, there is, after all, the overriding objective.
I mean, it's actually the way the court operates.
In practice, it is the way the court operates.
Yeah.
So,
you know, there's a lot of strictures in a lot of cases you haven't referred to where the Court of Appeal has said, and Lord Justice Moore Baker, as Vice President for several years, said it almost every day, and I sat with him a lot. You're limited by your grounds, and it's very important that your grounds are clear, and I'm not going to let you amend the grounds without very strong reasons for doing so. But ultimately, the real question is whether there's a very strong reason for doing so, and it's not unjust.
quite.
And
not prejudicial, which is kind of
exactly. But I mean, the idea that we're going to proceed on the basis that Adams has not been decided is ridiculous.
Quite.
Yeah.
Quite. So I was going to take you to Gover, to the case of Hickey, which we had in the previous bundle. That's a 2018 case, and that's quite robust on amendments. I don't think I need to take you to it, but you might like to look at it. And the recent case of Notting Hill and Shake is just makes the point that it's not fatal, that the point was not taken below. Not fatal, and you don't need to show exceptional circumstances. So those seem to us to be the key cases: Gover, Hickey, and Notting Hill. But if I'm right on that, where does that leave us in practice on this application for permission? Well, firstly, the application should be treated as an application for permission to amend, and not some other, not a fresh application nor a reopening of a closed appeal, because it isn't either. It isn't. Second, in its favour, I concede, is the fact that what both parties reasonably believe to be the law turns out not to have been the law after Adams. And therefore the floodgates will not open. But nevertheless, we object to all the amendments. I'll take them in turn quickly. New ground 1. So you need to look, I'm not quite sure where everybody has it, but need to look at the amended grounds of appeal, which were in red. I think they were attached to one of the submissions. So new ground 1 it does arise out of Adams, but we say has no reasonable prospect of success in terms of materially affecting the outcome for all the reasons I've given. New ground 2, which is the RAO 29 ground, does just about arise out of Adams, but we say similarly it is hopeless for the reasons I've given. New grounds 3, 4 and 5 are not pursued by my learned friend. New grounds 6 doesn't in any way arise out of Adams, and so there's no good reason for this point to be taken so late. New ground 7 doesn't arise out of Adams, and anyway seems to us to be the same as old grounds 14 and 15, which were declined, and then that would be reopening, and there's nothing exceptional to allow reopening. As to
It's
the
really
new...
7 on one interpretation is just a subset of 14 and 15, which were more broadly expressed.
Yes.
But they covered the same ground.
Quite. As to the new ground on the second appeal about section 382, that I concede does arise out of Adams, but should not be allowed because there's no real prospect of success. I cannot say we are prejudiced by any of the new points, and that is why I have argued them.
Yeah.
So, my lords, unless I can assist any further, those were my submissions.
Very helpful. Thank you, Mr. President. Yeah. Thank you. Yes.
Yes, my lords, I wonder whether your lordships would grant just a short adjournment of maybe 10 minutes before I address you, or
Well, how long is the address likely to be, or is it going to be shortened by 10 minutes?
it probably would be. I just need to clarify with those that instruct me in particular the ambit of my response, which in the light of particularly some of the observations from your lordships and indeed some of the helpful remarks made by my friend may well assist in ensuring that I can complete my reply by effectively 1 o'clock.
We'll resume at noon.
Thank you, I'm grateful.
Well,
3,000 pages. It's not, I don't think it's that huge. Sorry? Yeah, it's, the thing is that because I've always been using my desktop, you can see all my things there. It's one of these ones. Here it is. 25 meg. So yeah, it's a more compact. But I have one in your file. Very small, sometimes runs PDF. Slows down. Yeah, you're still using the same laptop that you've had quite a few years, I think, over those. Okay, I found out the Kickstand thing before, although I'm not sure that still exists. I did have a look. Does it? Big yoga. You have. I watched it. Great. Yeah, yeah. Well, that's what I was looking at on Jim.
Did you take
I mean, yeah, I was thinking.
the judge to the unagreed? Well,
Yeah.
you did, didn't you? Yeah. So they've got that, and you're not. There's no reason why they can't look at documents within that. Okay.
Well, I think it's sort of day by day.
Yeah, exactly. I appreciate it. So, well, this document is in there. I thought it was. Yeah, but I could. Yes, and would it? Can I tell the judge this on instructions? Is that approximately £28 million has been paid out to Liberty Sick ministers under that scheme?
Well, you can tell them. At what point does it go to?
I don't know. But you have no objection.
It's in volume 1, isn't it?
What is?
So I'm just talking about.
Yes, yes.
£62.
Yeah, understand. necessary to bring back it as.
Got your eyes. Oh, sorry, I'm not quite here yet. Sorry. Just setting up laptops. Got your eyes.
Yes.
Yes, I'm very grateful, my lords, for great assistance, and it will achieve the purpose, I think, of making my reply relatively efficient and economical. My own friend, when he opened yesterday his response to this appeal, he set out effectively a characterization of my clients, which and the nature of the investors, and gave your lordships an indication both yesterday and today of relative scale, so that your lordships had an idea of the nature of this and what I think the masters call, the ordinary person who isn't a party to these proceedings, but is very much in the minds of the FCA and no doubt judge. The purpose of this appeal is not to revisit that. We're looking at effectively what are black letter provisions within a regulatory framework, and whether things fall outside or inside a scheme which has consequences, as my learned friend has said. And whilst it's entirely appropriate when looking at individual provisions of particularly what the Treasury has identified as regulated activities, the court can have regard to the underlying policies that may have informed the definition of the parameter. In my submission, what one is not dealing in this court, and indeed I don't think that that Mr. Adam Johnson, when he gave his judgment, was seeking to express some form of moral outrage in relation to these matters. Ultimately, the issues that we've raised on this appeal, in my submission, are appropriate matters of law and construction. I'd also say that I acknowledge that the limited grounds upon which Avacade and which the appellants obtained permission from Lady Justice Aspling, were to an extent matters relating to definitions and the extent to which making arrangements was said to require some causative element, for example, or in the case of the Article 33 point, a syntactical question. But, my lords, significant sea change occurred with the handing down of the judgment in Adams, and given the time and resources available to the appellants and their legal representatives, we have, in my submission, coped well in terms of being able to put before the court what we submit are coherent arguments, which to some extent have to be modified and have been modified in the light of the Your Lordship's Court decision in Adams. And therefore, I I've heard what my learned friend has said today concerning the attitude of the FCA to the application to rely upon additional grounds or to expand the existing grounds in the form that we're seeking to do. And if I would respectfully commend that to the court as being necessary and valuable, particularly in regard to the again the regulatory context in which these matters have arisen. The second point that derives from the response to Adams, and it was very much, I think, highlighted by the Master of the Rolls, is that the parties have come to this court on the assumption and understanding that that Mr. Adam Johnson was wrong, was found to be wrong in his analysis in relation to step 3 and 4 in his judgment. And the issues that have been explored briefly this morning are important, and I note that your lordships are going to provide the parties an opportunity to deal with this by way of written submissions in relation to the issues that have been raised this morning, derived from the structure of the Liberty SIB, and indeed I think it may be sensible to look at the Guinness-McMahon and the other SIB, the Barclayburg SIB as well, in order to see the issue there as well, and I'm sure that that's what your lordships had in mind when indicating that you would allow the parties to deal with it by way of written submissions. I can tell your lordships, because it may be relevant to some of the wider elements of this case, and your lordships have certainly had regard to the wider issues, that in the case of Liberty SIB and Guinness-McMahon, there have certainly been investor claims brought under the Financial Services Compensation Scheme, and even as of today, on the FSCS website, there is information for people who might be eligible for compensation. Those screenshots are actually in one of the bundles before your lordships, because they're contained within what's called the appellant's unagreed supplemental bundle. I do have hard copies because they're probably easier to read if your lordships would.
Okay, we'll put them in. It's the unagreed supplementary bundle, is it?
That's right.
Could I just understand, what is this in response to, and what ground are we talking about, or proposed ground, or new proposed ground are we talking about if we're being shown these?
So I think that that in the first place, I think it is simply to provide you've been provided information concerning losses and concerning the position of my clients, which I'm not seeking to reopen or to go behind.
Right, so it's in response to general context.
General context, but also, my lords, it's going to be relevant also to my submission on the Article 33 point. Okay. Because, when I was making my submission that the SIP providers were not mere rubber stampers and owed regulatory duties to their clients, which would include potential clients. Well, we can see how that actually operates when one looks at what the Financial Services Compensation Scheme, effectively Division FCA, is saying in relation to the grounds upon which compensation might be claimed. So, with your lordship's leave, if I can hand up these copies, simply
yes.
easier to read than the.
Yes.
I'm grateful. So as I say, this appears in the bundle, but I've actually taken this from a screenshot downloaded today. And it records the fact that Liberty SIP Limited was placed into administration on the 27th of April 2020, and that as a result, FSCS is accepting claims against this firm. They are aware that FCA authorised independent financial advisors recommended many Liberty SIP customers transfer their existing pensions into Liberty SIP. Other customers made arrangements to transfer their pensions through unauthorised firms. After the transfer, many customers had their pension funds placed in high-risk, non-standard investment. Some of these have since become illiquid, which means they can't currently be sold or traded. And it goes on to say, for the FCS to be able to pay your claim, you must prove that Liberty SIP failed in its due diligence. In other words, did Liberty SIP Limited do certain checks on the non-standard investments that would hold their customers' pension funds before accepting them into its SIP investment portfolio? Did it make sure they were appropriate for a SIP? And did it identify any potential issues with them? And also, did it identify potential, if it did identify potential issues, did it tell the customer? And goes on to say how that can be done. Now, we've got an example, at least one example, in the bundle of one of the investors, the only investor I think who gave evidence herself in front of Mr. Johnson, that she was paid 100% in full under this scheme. And again, I don't think that I don't think it's unknown that the amounts that have been paid out under the compensation scheme run into many millions of pounds that have been paid out in relation to introductions by unauthorised investors, unauthorised introducers, including the Avacade companies, into Liberty SIP. And I think that's also part of the context when one looks at the specific matters that I want to now draw your Lordship's attention to by way of response. Again, I'm not going to take your Lordship to it because your Lordship's familiar with it.
Who funds the FSCS?
Huh?
Who funds
the industry?
The industry.
Yes.
Does that mean the regulated industry?
Yes.
Right. So not you.
Not me. No,
So what's this got to do with the general context?
Well, if first of all, if you will allow me to refer back to this when I look at the Article 33 point, because in my submission it will become relevant to the Article 33 point. The point about the grounds of appeal, the grounds of appeal which we seek to advance, on which permission has already been granted, I'm not going to rehearse those arguments again, but your Lordships will know that the point of difference between myself and my learned friend is the extent to which one looks at the need for a causative element or causative link when looking at the exception in 25.1 and 25.2. So again, I think we have those are effectively my grounds 1, 2, 3, and whether or not the Avacade companies, Avacade AA, could have availed themselves to the statutory exception contained within Article 25.2. In relation to Article 33, where we say that Adams does impact on Article 33 is because if we're concerned with the contravention being the introduction to Liberty SIP for the purpose of the transfer into the SIP, and that is the contravention in loose terms, not the subsequent investment decision, then in my submission, if one does, and one has to on the basis of Adams, isolate and consider that step as the contravention, as the regulated activity, then in my submission, the referral, the introduction to the SIP, in my submission, can be said to have been an introduction for the exercise of an independent discretion by the SIP provider, in this case, whether or not to admit the member into the SIP, whether that itself is a decision upon which we say the SIP provider does more than simply rubber stamp, it's more than execution only. It requires an element of diligence, it requires some responsibility to the potential customer, and in our submission, it therefore is relevant not only to the application of Article 33, it's also relevant to the issue of the chain of causation.
I mean, the problem with that point is that you weren't given permission to raise it. You were given permission only to raise a syntactical point on the construction of Article 33, not the next ground, which was the application of Article 3. And so, even if you were right that Article 33 is concerned with the contravention of the introduction of the fund into the Liberty SIP and not the subsequent investment decision, that unfortunately is not open to you.
Well, it's not open to me on the ground as then formulated, but we now have the grounds 6 and 7 in the grounds that I'm seeking to rely upon. And although they have a similarity, they are a resemblance with ground 14, on which we were refused permission. What we say is that it actually focuses now on the point of the SIP administrators and trustees' regulatory duties, and therefore seeks to reinforce the effectiveness, we would argue, that Article 33 provides to the introducer. Now, obviously, it's a matter for your lordships whether or not you will allow me to either amend my grounds or rely upon the grounds to introduce that. But in my submission, it doesn't fail on arguability, because in our submission, in the light of what has occurred, and we say particularly the emphasis now placed on the movement into the SIP as being the sole regulatory activity that we are concerned with in this case, which makes this case, my submission, very specific.
Where does this go on the evidence? Was there any evidence of, in relation to the 2,000 odd people who invested in the SIP, of Avacade clients being turned away?
So,
or is this merely a theoretical discretion?
It is. I don't think it's based on the evidence that in fact Liberty SIP did conduct diligence and then and then declined to accept people into the SIP. It's the difficulty that.
Wouldn't you need, in order to make this point, that there was a meaningful intervening step?
Yes.
Wouldn't you need to produce evidence to say, well, you know, we introduced 5,000 people, and after doing their work, Liberty SIP were only prepared to take X number from them?
I think that well, Justice Jackson's point is possibly a factual one in this sense, that the actual wording is that the introduction is made with a view to the provision of independent exercise of discretion. We're back to what was the purpose of the introduction.
I understand that you have many other issues to grapple with.
Yes.
I'm just trying to see whether this is a real-world point in which there was any evidence before the judge that Liberty SIP were turning away people, and that was part of your case below.
No, it certainly was part of my case below. I remember cross-examining one of the witnesses from the FCA at the trial, that the SIP providers were not doing their job properly. In other words, that they were not performing what they should have been performing in terms of their due diligence.
So far from there being instances of people being turned away, you were complaining that they weren't being turned away. Is that it?
There was certainly a thread that there was criticism to be made of Liberty SIP and the other SIP providers for their failing to properly consider the interests of their clients. But I can't. What we didn't have is evidence that they were performing the gatekeeper function and were turning people away.
Thank you.
That's my recollection. I'll briefly deal then with Article 29, if I may, because again, and I recognise that there are multiple layers within that which need to be addressed before it has a determinative outcome for every of my clients. But the specific issue that we've been addressing in relation to the Article 29 exception is whether or not the Article 29 exception was open to Avacade, having regard to the fact that it was said that they received a financial benefit. And a learned friend did address you in relation to that in the course of his submissions this morning.
Well, he said it's not a knockout point.
Yes. Yes, and that again assists me if the position is that the stonewall that prevents me from relying upon Article 29 is limited to those very few occasions where there was direct payment for the transfer into the SIP.
Yeah, but you've still got to deal with the application of Article 29 at all.
Well, and I've made my submissions on that yesterday, right. But my learned friend, so far as he was addressing you today on that issue, I accept I still have the other hurdles to overcome. And one of the themes, and again, I don't want to have to go back to repeat my submissions, but there's clearly a question as to how one approaches the sequence of events in relation to the lifetime of any one movement of monies from the original pension into the SIP, and then the investment decision and the implementation of that decision. And of course we've got that very well described in the judgment of Adam Johnson, who does assist the court significantly from paragraph 92 onwards, I won't take you back to, but you also will be familiar that in relation to each of the entities, in relation to each of the models, the judge was painstaking in setting out all the relevant administrative and other steps that were being taken. And so there's a point of principle which I think arises on this appeal for your lordships is how does one view this in the light of the fact that we now know, on the basis that Adamson option is applicable, that the only step that we're concerned with is step 2, and that therefore gives rise to the question of whether or not this should be seen as one continuum, one unbridled train, or whether it can be compartmentalized and segmented as we suggest. And I don't think it will assist your lordships if I simply make that point again, but your lordships have my point in relation to that. We say that because Adam Johnson never really had to consider the point, because he regarded every step as being a step which involved a regulatory activity. He didn't have to do what your lordships have to do, which is to ask oneself, is there in fact, is it too remote, is it too far down the chain of causation that the investment decision and the implementation of that decision whilst in the SIP at a time which is when Avacade and AA are powerless to prevent it happening, does it follow that they are causative of that, and is that the correct approach? And it can be tested a number of ways, and your lordships did test it when the loan friend was dealing with the matter. The issue of what would happen if, for example, the movement came whilst the whole approach, not necessarily by Avacade, but the whole approach, say, by an unauthorised person, had come whilst the funds were already sitting in the SIP as opposed to coming into the SIP. What would be the position, for example, if there was no investment from the SIP after the movement into the SIP? The fact is that in those circumstances, as we understand it, the Avacade and AA wouldn't be receiving any reward of financial benefits. So
presumably they wouldn't provide any more clients if that was the case.
Well,
they weren't going to get paid. They'd stop the arrangements.
Well,
and also, I mean, while I've interrupted you, you spoke a moment ago about Avacade and AA being powerless to prevent the investment. But the judge's finding was that it was your entire raison d'etre to make sure it did happen. So what's powerless to prevent?
yes. Yeah, I mean, they can bring the party into the ring, but what they can't do is they can't then they haven't got the capacity to be able to be instrumental in the entry into the investment itself. And just to again, I'm not trying to in any way trivialize any of the issues in this case, but looking at it in this forensic manner in this court, what I submit is that one does have to look at the individual steps and concern oneself at each stage. Well, what does that step produce? What does that step achieve? And in my submission, the only step we're concerned with is that there was an achievement of the movement into the SIP, in respect of which Avacade in most cases got little or no financial benefit. But I've made those points, and unless I'm required to, I'd like to move on to what in my submission is an important point, which is the section 382 point, what the second appeal really turns upon.
And now you accept, do you, that if Adams is irrelevant because in fact here the transactions were entered into buying and selling by the consumer as trustee, this is not a good point, because they were involved in all the transactions.
Yes, I certainly would accept that I'm not going to make any formal concession, so I have to be careful. But what I would say is that if on a proper analysis, this is not an Adams case because it is a sale by the member, by the investor, and if it were the case that constituted a regulatory step, despite the apparent concession and the basis upon which the FCF approached this appeal, I do accept that it has significant ramifications for the force of my submissions.
Yeah, thank you.
Can I deal though with section 382, and it's important to distinguish, as I sought to do yesterday, and I think without disrespecting my friend, we perhaps elided the two. The distinction between the section 382.1, which is unlocking the jurisdiction, and the approach of what remedy should actually be ordered, which appears in section 382.2. I don't know whether your lordships want to go back to the sections, or whether your lordship have that familiar.
Yes, we do want to go back to it.
I'm grateful. So again, it's at page 21 in the authorities manual. And as I point out, the section 382.1 is dealing with jurisdiction to make an order. Section 382.2 deals with how the power may be exercised by the court when making an order. And my learned friend wanted to use language of causation and suggest that issues concerning what one would regard as losses flowing from or caused by events may be relevant to what actually has been suffered, what actually has been gained. That's not really the exercise that the court is performing at the 38.2.1 stage. And can I say that Mr. Houseman, Sir Stephen Houseman, Queen's Counsel, sitting as the judge dealing this matter, he provided a detailed judgment, and he does deal considerably with the methodologies upon which loss can be assessed and the methodologies by which loss can be identified. But there isn't really an analysis of the section 382.1 point. And that.
Well, did you ask him to analyse it?
My learned friend Mr. McGarry appeared on that application, and Mr. Temple appeared, and in fact, the position is slightly more difficult for me. I think not only it wasn't argued, there was, I think, an assumption that the parties could go directly to the question of how you quantify loss, and what was being raised there was the question of the uncertainty of the loss, and there was also reference to the scheme that I referred to, the financial services compensation scheme, which might affect the question of what losses might be. I don't know whether it would be helpful to go to the judgment as well of. So it starts at this paragraph 46 in the judgment. The judge refers to what he calls a wide remedial. He actually, I think, mentioned it. Paragraph 31. Paragraph 31 in his judgment is where he introduces it. So paragraph 31 in his judgment, the judge describes section 382.2 as conferring a wide remedial discretion upon the court to make an order for such sum as appears to be just. So having set out the statutory provision 1 and 2, he goes directly to 38.2, which is the exercise of the discretion, what he describes as the wide remedial discretion. And then if one goes to and he links it also to the ability of the court to make interim orders, which under the CPR, which I'm in trouble with. And then at paragraph 46, he says that the remedy, this remedial jurisdiction, is intended to operate flexibly. It's not equivalent to the common law, and he lists the fact that there is a series of factors that can be taken into account. And I'm just pointing out at this stage what the FCA's primary case was. So the FCA's primary case was to work on the basis of the assumed loss, and so they arrived at a significant figure which was based upon the assumed loss by the investors. There was then an alternative model advanced, which was called the gains-loss proxy, which assumed that there's an equivalence between the gains derived and the losses suffered. And that was actually what the judge used as the methodology for ascertaining the sum from which you would then calculate what interim order to make.
Well, is that right? That's so for the companies.
Yes.
But for the individuals, he did it simply on the profit basis. Isn't that what paragraph 65 says?
That's right. But what he didn't do, is he didn't do it on the basis of an establishing loss. You can actually see, he says that explicitly. But in answer to the point, I ought to have an obligation to point out, I think, that if page 271 at paragraph 59, you can see that he says that the represented defendants do not contend that this court cannot be satisfied that the threshold or gateway requirement in 3821B will be met in relation to each of them. And he himself deals with it by saying he was satisfied that some loss, that one or more persons have suffered some loss or been adversely affected as a result of one or more of the proven contraventions in respect of which the three individual defendants were knowingly concerned at all times. So that's his dealing with the gateway, and one can see that the question of loss, which is likely to have been more regarding what is the likely amount. This is probably, although he doesn't say, this is probably now going to his exercise of discretion point when he's looking at the models of loss and profit that the FCA were advancing. You can see at paragraph 61.
I mean, I don't really get this. I thought your point was a simple causation point.
Yes.
That if you're right about Adams, then you cannot show, or they cannot show, not because of what Mr. Houseman decided, but because Mr. Houseman did not know about Adams, or was not put to him, and he decided, in the words of Section 382 that I've just got it here. That it was just to have regard to the profits which had been arisen as a result of the contravention, and they hadn't arisen as a result of the contravention because they arose from the entry into the SIP only.
Yes, and that...
They didn't arise from the entry into the SIP only,
Yes.
which was the only contravention.
Yes.
So how do we benefit from having an analysis of what Mr. Houseman said about a completely different point?
Well, it goes... The words "as a result of" and what we're looking at here is arise under Section 382(1).
Yep.
And that's the jurisdiction of whether or not he's got the jurisdiction to make any
Yes,
order at all.
because the such sum as may be just is such sum as may be just, having regard to subsection 1.
Yes, but at the moment, what we're seeking to make good as our submission at the moment is that if one takes it transaction by transaction, and that may or may not be the appropriate approach. And we said that is the proper
No, but
stance.
you don't have to apologise for your submission that it is the appropriate approach. So that's your submission.
Yes.
That you should take it transaction by transaction.
And there will be many, but the majority of the transactions occurred in circumstances where, first of all, there was no, as a result of that transaction, which is the contravention in question. The contravention in question, we say, is linked always to that transaction and movement into the SIP.
It's an incredibly simple point. I mean, it's either right or wrong, and it turns entirely on the single thread question. And if you're right that the contravention is simply point 1, then the losses that arose from stage 4 were not as a result of the contravention, you say.
Yes, but I just want to come back on the question of the single braid point, because it actually goes further than this. It goes further than that. I mean, one can understand the single braid point if we're dealing with the causation of loss generally. But my point is probably more fundamental, because my point is that they don't get to unlock the jurisdiction, because the wording here is "as a result of." As a result of is not a question of causation. It's a question of whether one thing has followed from the other, whether it is as a result of that.
Sounds to me rather like a test of causation. I'm afraid I don't quite understand what you mean by saying "as a result of" doesn't pose a test of causation.
So if one adopts the transfer into the SIP or making arrangements, say for the transfer into the SIP as the contravention, then the question then arises: has the FCA demonstrated, has the regulator demonstrated that as a result of the making of the arrangements for the transfer into the SIP, that profits have accrued?
Yeah, yes. But that's the point that I've just put to you. If you're right about that, you're right.
Yes, well, the word accrued means the profits have accrued as a result of that contravention. If the question is, has he received the benefit consequential?
Well, I mean, that's the case for 1A, but 1B is slightly different, because 1B also requires, or can require, that a person has suffered loss or been otherwise adversely affected as a result of the contravention.
That's right.
But again, if you're right that as a result of the contravention is to be construed strictly, and the contravention, and you're right about Adams being applicable, then this is a good causation point.
Yes.
But it all turns on the single braid, because if the single braid is right, then the contravention they are adversely affected, or could on one analysis be adversely affected by the entire scheme, which includes a contravention. So then the causation is a question that may be answered differently. But I mean, I entirely see your argument. We saw it in opening. So,
Yes.
but what's your reply point here?
Yes, my reply point is this: is that the single, even though we don't adopt the single scheme or the single grade approach to the general questions that arise more broadly in this case, on the specifics of the jurisdiction clause within section 3821, what Parliament has chosen there to use is language which we suggests that there's only limited ability to obtain the remedy, and that's where the profits have accrued or the loss or the adverse affectations occurred as a result of the specific contravention. And we say that that doesn't require a prospective, forward-looking, the single grade or the single scheme. When one's looking at the individual contravention, that will have consequences. It'll have consequences which will lead potentially to restitution orders. But one's going to take money out of people, and this is not equivalent to common law damages. It is about effectively a statutory remedy, which is actually brought not by the person who's the victim, but brought by the regulator, who then has the power to deal with it. Parliament is it's only derived from. It has no parallel within the common law. It's derived specifically from the language of the statute, and in the language of the statute, there is a requirement. In order to unlock the jurisdiction at all before dealing with what is just and broader considerations, did the contravention have the result? Did that contravention result in the loss being suffered or the adverse effect taking place or the profits accruing? The word accrued and the word suffered suggests that the snapshot that we're dealing with, the point at which we freeze time, is the time when the contravention occurs. So, I mean, I don't think, as you say, it is a small point, but it's an important point. And it's certainly an important point broadly, and my clients have a significant financial liability as a result of this interpretation, the wider interpretation, and we submit that on a careful and proper analysis, which your lordships would be undertaking, the answer is that now that we know under Adams we're concerned simply with that one contravention, that the jurisdiction was in fact never unlocked. Unless that can assist your lordships any further.
No, that's the point. Yes.
Are there any other matters that your lordships would?
No, well, we must make, unless my lords have any other points, we must make directions for these submissions on the applicability of Adams.
Yes.
I would suggest that we don't want to be too generous, because we would like to get this judgment out before the end of term, and the end of term is rapidly approaching. I don't make any guarantees whether we will. But would it be possible for you to produce those submissions by... I'm thinking as to whether it's necessary to do them sequentially.
Yes, I was going to suggest that they be done sequentially. It'll actually save, I think, time if we do it that way, because effectively...
Well, who goes first then?
My learned friend, because the status quo, the way we've approached
Yes, okay, the status quo is
in
not,
my favour.
yeah.
So let my learned friend make a submission. We'll respond to that, and it'll save time.
Right, well, if he did submissions by 4 p.m. on Friday and you did submissions by 4 p.m. on Monday, would that be all right?
Friday tomorrow?
Yes.
Well, no, because I think, well, I shall be telling, indeed, I have already told the FCA that they ought to ask a pensions expert, actually. And I'm not one.
4 p.m. Monday and 4 p.m. Tuesday.
Well, my lord, could we have longer than 24 hours to respond. As I've tried to
4 p.m. Monday and 4 p.m. Wednesday, but I'm not taking any further negotiations. Right, so Thursday, you're happy with Thursday? Yeah. All right, well, then I'm going to say 9 a.m. Tuesday for Mr. Final and 4 p.m. Thursday for you.
I'm sorry to be difficult, but I know that Thursday I'm going to be travelling abroad, which means that I won't get to my destination for the evening. Could it be 9 a.m. Friday morning? Give me an opportunity to consider. Thank you very much.
9 a.m. What did I say? 9 a.m. Tuesday.
FCA.
And 9 a.m. Friday.
I'm very grateful.
I feel like an auctioneer. Good. And that it would help us if you do want to refer to the terms and conditions of the other IFAs, or the other SIP providers, please attach them to your submissions. And we're not encouraging a great debate about it, because if Adams doesn't apply to Liberty, that is the bulk of this case. But I freely accept that the terms may be different for the others, and we should know that at least. Okay, well, it only remains to say that we will obviously reserve judgment. We'll hand down the judgment in the usual way. When we do, please agree ancillary matters and costs, and if you can't agree, those matters will be dealt with in writing. Many thanks to you both.